I'm not actually.
Hi, good afternoon, guys. How are you?
Hi, everybody.
Nearly you caught Leonie doing a very bad thing. No, not really. Okay, a little bit unscheduled. However, I think we need to quickly discuss a few issues that's been coming up, Leonie, especially amongst the questionnaires and the questions coming through email and also telephonically. You will know about those things. My dear, how are you, sir, by the way? How are
Awesome,
things running smoothly? Okay. The first thing, guys, and it relates to once again the whole issue of resignation in the workplace. Now, for some reason, and I think I know where it stems from, Leonie, we've had so many different cases now. Once again, where people say that the employer is busy constructively dismissing us. And then I'm going like, why do you say that? Where do you get the information of constructive dismissal? And the person would then say, no, but we spoke to this or that or the following person, and we know who those people are. And they advised us that if the employer does this, we can resign and refer a case of constructive dismissal. Now that, unfortunately, is pure folly. Listen to Skulk now, yes. And listen well. People, yes, there is crystallized law in South Africa relating to what is called a constructive dismissal. Constructive dismissal is where the employee terminates services and then refers a dispute to the CCMA. But, and here's the very important but, two aspects you need to remember. One, you carry the onus of proof, employee, not the other way around. Not section 192.2 where the employer carries the onus of proof. You must prove. It's a difficult onus to prove. It's a difficult onus to bear. Number two, and this is very important. During the investigation by the Commissioner at CCMA, he will see and he will do the interrogation to see if you have indeed used and utilized all other remedies that were available to you before you resigned from your duties. And if he finds that that was not the case, you will lose. Full stop. So yes, theoretically, there's a thing called a unicorn, which is a horse with a horn on his head. But very few of us have ever seen one. Only maybe if you have a little bit of a psychedelic in you. Maybe then possibly you will see a unicorn. The same with constructive dismissals being one at CCMA. I'm not aware of a single one. Literally not a single one. I can remind me vaguely of a case where a worker was not paid for a certain amount of time, and that caused him to fall into such a state of impossibility to perform his duties that he could not turn up at work, etc., etc. And in the end, he won that case. But that's a singular case in a whole sea of case law against it. So please, people, do not fall for this nonsense advice of inexperienced lawyers and consultants about constructive dismissal. Also remember that if you resign from your duties, the net effect of that is you are terminating the contract and therefore you cannot, for instance, then go and claim UIF. You must remember that because you bring the fault onto yourself. You bring the breach of the contract, and it's a legal breach if you give proper notice, but you bring the termination onto yourself. Therefore, you cannot claim UIF. You cannot take the case to CCMA. So please, just stay away and just steer clear of this nonsensical advice of the employer is now constructively dismissing you. There's no such thing. You're falling for the wrong advice. If you put your hand on paper and you resign, you resign.
Yeah.
And yeah.
We've said this so many times. Do not resign.
Yes. Today alone, and I'm certainly not going to single out clients because they have been advised incorrectly. So I'm not speaking about the clients. Ek beklei nie met jou as 'n kliënt wat vir my bel nie. But today alone, I think we had 4 or 5 cases of people saying to us, but Skull, please, let us refer a case to CCMA now. We've been constructively dismissed. And I'm sitting there like, not gonna fly. Don't be angry at me, it's too late. Not gonna fly. Okay, so only in the most severe cases where all remedies has been utilized, Department of Labor, grievance procedure, going to your attorneys, well, any and all remedies internally, then maybe you can think of resigning. The classical case or the classical instance where I've found many times that people resign constructively is with sexual harassment inside the workplace. People, you can't resign, especially female employees, just because you believe that there's sexual harassment going on in the workplace against you. You must then utilize the proper channels of raising a grievance, and that grievance must be properly investigated, and then you also have the availability of the police. You can go and open a police case. You can go to your attorney and they can write a letter. But it does not mean that you can, unfortunately, then resign from your duties. The other classical one of you're not being paid, that's a payment dispute. You take it to Department of Labor. If it's a simple payment dispute, they've not paid your salary, and the Department of Labor is supposed to then issue a compliance letter to the employer. So it's also not enough or sufficient grounds for resignation that will constitute a constructive dismissal. Okay, so people, please do not fall for this nonsense, this absolute folly about this.
Don't get bullied into it.
Yeah, especially don't get bullied into it. Okay.
You don't have to resign, so let the employer do their thing.
Let the employer make the mistake.
Yeah.
Dit klink miskien 'n bietjie skelm, but unfortunately, if the employer wants to get rid of you, then he must draw the risk onto himself. It's as simple as that. So please do not run around with advice. Consultants out there and inexperienced attorneys out there, I've never heard it of advocates, but please do not go and run around with advice to your clients of constructive dismissal. It's like a unicorn. Okay? So please, I made a little joke about it, but please do not give advice like that. Please just don't do it. Okay.
I agree.
So that's the first thing that we wanted to discuss. Secondly, once again, from a lot of people speaking to us at this point in time, it's now at the tail end, at the back end of the whole COVID mandatory vaccination, and you have a lot of vaccine injuries, and you have a lot of employees. What's it, my dear?
No, nothing. Sorry.
You wanted to point out something to me. I don't have my glasses on.
You don't have your glasses on.
On the tail end of this whole thing, we know there's going to be a huge amount, a huge number of disputes relating to unfair dismissal, unfair labor practice based on people not being paid for the time that they sat at home, but also then civil cases coming out of this whole thing. We know this. Now here is something extremely important. And I think we have visitors, so the fur kids are getting extremely restless. Here is how an attorney's firm works. An attorney's firm is a business. There's telephones to be paid, there's rent to be paid, there's clerks to be paid, there's staff to be paid, there's stationery to be paid, there's all kinds of other cost elements to be taken into account. It's a business, right? It's not a clever person sitting there with nice certificates in the background and just simply speaking and the money is rolling in and he's filling his pockets. For the most part, and this is something you need to understand, that I'm standing now a little bit for my brothers in the profession of attorneys. Attorneys are usually not very rich people, contrary to popular belief. They usually have a lot of debt, but they are usually not very rich. And what do I mean with that? How does a case work? You go to the attorney and you tell the attorney, this and that and the following happened. And then the attorney will say to you, okay, this is what we can do, and this is how much it's going to cost, right? And then you will take a certain amount of money onto a file. I'm speaking of litigation here now. I'm not speaking of other areas of law. You will take a certain amount of money into his trust, and from that money, he must then initiate the whole litigation process. He must initiate, for instance, the serving of documents through the sheriff's office. He must initiate letters being sent hence and forth, paying advocates who comes and then saying, well, we need a certain amount as a fee, as a deposit, even whatever, before we see your client so that we can take the case further. Sometimes only the opinion of an advocate is needed, and sometimes that opinion can run into thousands of rands, because an advocate will have to go and sit and do research for hours upon hours and then write a proper opinion, right?
Yeah, around about 20,000.
It's easily.
Yeah.
That's easily. A well-written legal opinion by a senior counsel can easily run 20,000 rand plus. That's only a written piece of paper opinion by a senior counsel.
Leave us, we know.
Right. That's a long and short. So why am I saying this to you? There's a reason I'm laying this basis to you. Leonie, we have had it now again. That people are bamboozled by unethical attorneys telling them the following. You have a good case, but this case needs to go to court, and it must go to court urgently. And therefore you must pay us a deposit of 40,000 rand or 50 or 70 or 100 or whatever, and then we will take this case on an urgent basis to court. Right? And then if you win, we will take a certain percentage. I heard one attorney even asking 70% of the final amount supposedly to come out of this. This is pure nonsense. It's bamboozling clients. It's stealing from clients.
So if you hear an attorney saying that, stay away.
Okay, here's the thing. If that attorney tells you your case is urgent, get a second opinion about it. Urgency in court means that you go to the High Court, usually this is High Court, to the High Court, and you go to that court saying to the administration, let's call it, we speak in layman's terms now. You speak to the administrator of the court to say to him, you must now put this case onto the roll, move other cases that's already on the roll out of the way, because this is now urgent. It must be brought before a judge urgently. Right? That's the first obstacle. And then only if you can prove it is urgent will the judge listen to the merits of that case.
Which you can't.
Now here's the problem. Most cases brought on an urgent basis is not urgent. It's a very difficult hurdle to cross. So you will unfortunately find these unethical attorneys that tell their clients, you must pay us this huge amount of deposit, and then we will run urgently to court, fully knowing that they will not be able to prove urgency, and therefore the case will be removed from the urgent roll and put back on the ordinary motion roll. And then the clever unethical attorney will tell his client, oh gosh, yeah, sorry guys, sorry for you, we lost now.
For the deposit.
Yeah, sorry, we lost now. It's that bloody judge. Yes, we know him as being difficult. It's not our mistake. But now your case is on the motion roll, and it will cost you another 100,000 rand. People, I'm speaking here of daily reportings to me from the professions. Right? That is why I'm warning you. Stay away from attorneys who runs after money. If an attorney's first thing is about speaking of money, then you know you're sitting with a problem. Also, feel free to get a second opinion, like you would have with a doctor. Get a second opinion also on your legal issue. To hear from another person, totally unrelated, another professional, what he or she is saying about it. Before you commit tens of thousands of rands, usually it's a group of people, and they all contribute because they are not very strong financially. They can't afford that attorney or the amount on an individual basis, so they pool. Before you do that, please make sure there is a viable case you can take, especially if we're speaking High Court. Because the chances of an urgent application failing at High Court is like a constructive dismissal at CCMA, is virtually a surety. You must really have an extremely good reason for a case to be put on the urgent roll and be successful in that. Okay, I must warn you about that. Anything you want to add?
Not at the moment.
Not at the moment.
Not at the moment.
Okay. Then, unfortunately, you also have the ambulance chasing type of attorneys who will say to you, I will take your case, and only if you win this case, I will take a certain amount. Right? It is not unethical for an attorney to do such a thing per se, but here's the practical problem of it. If that attorney must put down a certain amount of time, a day or 2 or 3 or 5 or 10 at court, he must prepare for the case. He must maybe brief an advocate on his own trust account now, from his own monies, his own funds, not being paid by you.
That's what they call pro bono.
It's at some point they are going to run out of money and oomph.
Yes.
Right? Because
especially oomph.
an attorney must also eat.
Yeah.
He must also have a roof over his head. And he also have accounts to pay off. I just spoke about his costs just to simply run his law firm. Right? Now, how can you then put your whole law firm on risk taking these cases not being paid up front?
Yes.
So all the red lights must come on when you have attorneys doing business like that. I don't say it's impossible. In terms of the rules of the attorneys, they may do certain pro bono cases per year. There's actually a certain number in terms of their own rules. I'm not an attorney. I don't know exactly how it works. But when you have a pattern of attorneys doing this, you know you're going to end up with problems. Right? Usually what will happen is after the first or second appearance, the attorney will come to you and say to you, yes, like, we're now in the midst of this thing, we have so much, it's such a good case, but now I need money. I need 10 or 20 or 30,000 rand. Fully knowing that you are now so embedded into this thing that if you lose, if it's a civil case and you lose, you're most probably going to get a cost order against you. If it's a criminal case, it's even worse. If you lose a criminal case, you go to jail, right? So they catch you with all these things, and be very, very careful of things like that. I really wanted to put this warning out. It's strange to me this last week, Leonie, we've had so many of these instances. And once again, you know your culprits, you know the people in the business. It all runs to 1 or 2 or 3 or 5 people. Always. If you start asking questions, you know who's involved in these things. You start to know the names. So be very careful. I'm not at liberty to divulge names on Facebook. I've been even taken to High Court and gag orders gotten against me on an urgent basis, which was also struck from the roll and then later on the motion roll. But the long and the short is, if these red lights flash, run. Don't even think about it, run.
Otherwise,
right?
You're just going to lose money.
You must remember that law, to me, Leonie, people working in the legal profession, to me, law is nothing. It's just something. This afternoon, I was advised of certain documents delivered by a certain sheriff at a certain place. I phoned because I have the sheriff's number as his cell phone number on my telephone. I phoned him up and I asked him, did you deliver documents there and there and there? Yes, I did. And I asked him what was the nature of the case. No, this is what I read on top. Okay, boom. So I know what the case is. That is how little it troubles me. But for the person receiving that thick piece of litigation, it freaks that person out, because that is now the focus of their lives until that case comes to an end. And usually it's extremely emotionally loaded. And therefore, you can be manipulated into a position of taking out money and fighting a case that you will never win. You're throwing my good friend down in Welkom, Casper Creer, I always use Casper when I do my litigation down in the Free State. He always says, don't throw good money after a bad case. And what do you mean by that? If the case is not winnable, do not go and spend 100, 200, 300, 400, a million rand on that case. And you're not going to win. You're just enriching a lawyer by doing that. You're not winning anything. You're not, the emotion in you, you want to fight. You want to show the other party. Don't come and mess with me. I'm going to fight you now. That's all good and fair. But the problem is that you need to pay the bill in the end.
Yes.
Even if you win.
And be careful for documents. That's this thick.
That's, oh, Leonie, let's quickly discuss that one. I see certain lawyers think that they can throw you, boom.
Because it's a tactic.
With this amount of documents.
And maybe a day or two before.
Yeah, exactly. Usually a day or two, this is now the urgent ones. The urgent ones coming in. A day or two before the time, or 5 o'clock, you will see your machine going up and down, and all documents are being thrown there on the ground. It's chaos. This thick. But then it's an ordinary, easy, simple application that only would have had maybe 5 to 10 pages with its annexures. There's a reason why lawyers do that. There's 2 reasons. Number one, of course, for every document, for every page in that bundle of documents, you client pay. So it's making money. Secondly, it's a scare tactic on an experienced litigator on the other side, because if you receive that, you think, oh my gosh,
yes,
let's run, they're going to win. But if you start paging through the documents and you're a skilled litigator and you know how law works, you laugh at the things that are usually in those thick pieces of documents. When I was still very junior prosecutor, I was trained here at Justice College, not very far from where I'm sitting here in Pretoria. They always say to us, look at the defense lawyers coming into court with these big briefcases and these thick books and all these documents, and they stack it there, doom, doof, doof, there in front of them. It looks like they're building a castle in front of them. You know those lawyers doesn't know anything about law. You know that. Because if he needs to carry around that much in paper, then there's nothing upstairs in his head. Now, the same with court documents. If you can't knock out your opponent in the first 3 pages of your document, you've lost. It's as easy as that. So it's very good you brought up that point also. Be careful of lawyers sitting there with all these thick pages and thick documents and thick bundles of things.
It's unnecessary.
It's usually totally unnecessary. We recently, on a more personal level, we had a case where a counterparty filed 6 times, 6 supplementary affidavits or something like that. It was literally laughed off by court and by other legal professionals when they saw that, because the nature of that dispute was so simple that if you couldn't defend it within 2 or 3 or 4 pages in your replying affidavit, then you didn't have defense in the first place.
No, but that's what happens when you're malicious.
It's maliciousness, yes. Okay, so we discussed a lot of things this afternoon, general things, because we're starting to pick up the strength now, and the strength is going to get bigger as time goes by, because there is a huge amount of work all of a sudden for legal professionals out there. There's VAX injury cases. Let me quickly touch on that in a moment. There's unfair labor practices. There's unfair dismissals. There's a huge amount of work all of a sudden coming out of this quagmire of COVID and lockdown and forced vaccinations and all these things. So you as an individual, please from your side, be very careful of who you entrust your case to. And don't be scared and don't be intimidated into getting a second and even a third opinion about your case.
And do your homework first on that person.
Yes, that's also true. That's also true. Be very careful if people try to catch you or try to entangle you, or be very careful or push you, or if you're good enough, clients come to you in scores. You don't have to go and push them and crook them into a position.
Yes.
Then your phone doesn't stop ringing. and your email runs over, and your WhatsApp is so full in the morning that when you open it, you feel like just climbing back in bed because you see there's like 300 messages, right? You don't, a good practitioner never has to go and field for business. They never have to go and, how can I put it, draw you in like a spider would do with a little fly caught in a spider's web. When you have that type of lawyer, you know there's going to be trouble. Okay.
Something I actually wanted to ask you yesterday is when I said I forgot.
Go.
I remembered now. So it's regarding our website. I want you to just explain to people what the difference is between the 1,750 and the website.
Oh yes. There's people who don't understand that. I never even thought about representing employees. Then the whole thing of COVID came up. It was very clear that a vast majority of employees out there couldn't even afford the most basic legal services from an attorney, or for that matter from advocates at the bar, whatever. And therefore I climbed into that market. I basically monopolized the market, and that is why everybody is so angry at me. And yes, I had the 850 package with which I literally serviced thousands of people. We also had free service for those people earning less than 5,000 Rand. We serviced literally thousands of people. In the meantime, the 850 has been phased out. People now pay me a consultation fee, 1,750. It's a consultation fee. It is for you to get the information, to exchange documents, for me to interpret those documents to you. Sometimes I draw up documents for people.
It's personal attention.
It's personal attention about your case. If we can solve it there and then, sometimes I call an employer and I say to him, or another party, and I say to him, let's just speak about this thing. And like that, we solve the problem. Sometimes it's a little bit more difficult. Sometimes the thing needs to go to CCMA, or it needs to go to court or whatever, but then you're quoted separately for that. But paying me 1,750 for a consultation is paying for a consultation. That's it.
And personal attention, and like you help them all through the way.
Yeah, and that stands totally different or differentiated from paying 150 or 300 Rand per month when the knowledge hub is going to start up. I intend to give my clients, my 11750, my clients, 1 free month as a bonus when they utilize my services. But the two is not interlinked. So don't think that if you pay a consultation fee now, all of a sudden you also have access to the knowledge hub of the webpage. And vice versa.
Yes.
Don't think that if you pay me 150 Rand a month, now all of a sudden I can do a lot of legal work for you. Not going to happen.
No, because the website is self-help.
Yeah, it's a self-help portal. You're going to find the whole legal library there. You're going to have videos. You're going to have everything that you need is going to be there for you to utilize yourself. Okay, so it's a very good question that you're asking. Thank you so much, my dear. Okay, guys, we spoke about a lot of things this afternoon, but I think it was necessary for us to explain these things to you. There's so many people out there now scamming, stealing, because people are really getting desperate in the situation that they are. And desperate people, unfortunately, do stupid things. They fall for scams that they would never in their lives would have fallen through. So before you become involved in litigation, before you become involved in anything that's going to cost you money, go and sit for a day or 2 days or 3 days and think about what you are doing before you engage into this. Okay, now our fur kids engage one another. I think we excuse Leonie from here. Guys, that's basically all I wanted to say and all I needed to say. Maybe later on tonight I will speak to you again. Definitely tomorrow I will speak to you again. Thank you so much for your time. And Leonie is back. Just show that fur kid to the people also.
She just wants to fight.
The little fighter, the little feisty one. Just like a mother. No. Just like a mother. Anyways. Yeah, I salute you guys. And then we see one another definitely tomorrow and maybe later on tonight.
Yeah.
Okay.
All right.